My learned friends, Mr. Gill, Casey, and Mr. Merman appear for the respondent.
Thank you.
My Lords, this appeal, as the court knows, raises a short question as to the proper construction and effect of Section 22(3) of the Counter-Terrorism and Security Act 2015 and the authority to carry scheme. In broad terms, my Lords, the ATC scheme is a system under which airlines and other carriers must seek the authority from the Secretary of State before carrying certain passengers to and from the UK. If the Secretary of State refuses the authority to carry a person, the airline or the carrier must not carry them. My Lords, the judge below held that on a proper construction of Section 22(3) of the 2015 Act, the ATC scheme cannot be applied to a person who poses no terrorism-related threat. Subject to your permission, my Lords, I shall seek to persuade you that the judge's construction is wrong and his conclusion is flawed. The ATC scheme is not limited to those who pose terrorism-related threat. It applies also to those who are subject to a deportation order or action. So subject to any observations, what I propose to do this morning is to address you first as to why the court should decide this appeal. And subject to your permission, I will then make submissions on the question of statutory construction that arises in the appeal.
Yes.
So why should the court decide this appeal? In my submission, for 5 reasons. First, the question that arises in this appeal is of general importance.
So sorry, I just didn't hear. The question is what?
It is of general importance.
Yeah, thank
you. It is of fundamental significance to the administration of immigration control. My Lords, last year there were over 4,600 refusals to carry under the ATC scheme. Out of those refusals, only 15 concerned terrorism or national security. Others were immigration-related refusals. The scheme, my Lords, is applied on a daily basis to non-terrorism-related immigration cases. And the judgment below has created substantial uncertainty as to the legality of the current operations. The court should decide, in my submission, whether the Secretary of State has got the law wrong or whether her current scheme and the application is lawful. A judgment by this court will end the uncertainty. The Secretary of State, airlines and other carriers, indeed foreign national passengers, would know what the scheme can lawfully cover.
Is what you're eventually asking us to decide simply whether 14F is covered, or whether which is the one about deportation, or whether all heads are covered?
The question that I'm asking with respect to the court to decide is whether the scheme applies only to those who pose terrorism-related threat. This is what the judge below has held, and it is that conclusion that the Secretary of State respectfully seeks to impugn.
That, I mean, may be the right question, but it would leave an excluded middle, because it would say no, it doesn't just relate to terror threats, but it doesn't say yes, it does relate to other circumstances. It's simply a statement of a negative.
Yeah.
Is that the extent of your request? Is really what we need to be clear about.
Yes, my lord. But just to answer my lord's question, well, that is the extent of the request. But that request, my lord, is of course linked solely in this appeal to 14F.
Well, I asked the question because I've noted you down, as you were saying you were trying to persuade us that it didn't apply only to terrorism-related cases, but to 14F cases. But later you used the phrase immigration-related. 14F implies a certain level of seriousness because they will have had to have been convicted of criminal offences of a certain degree of seriousness, which are statutorily deemed, where deportation is statutorily deemed to be conducive to the public interest. That's not true about a lot of the other heads under 14.
Yes. Yes.
So which are you trying to persuade us?
So I'm not asking the court to look at any other heads in this appeal.
Only 14F.
Only 14F. Yes.
So it's not just terror. It does include 14F, full stop. That's how you frame the issue.
Yes. Yes, indeed.
And that would actually fit with this case because I just checked the order. The order was it was inapplicable to him.
Yes.
And he is a 14F case.
Yes.
Right, so if anybody wants to run an argument on another occasion, they can't possibly relate to something of a lesser sort, even though listed.
Yes.
That would be for another day. Is that your?
That would be for another day, unless, of course, the court concludes that Secretary of State has got the law wrong and it's all terrorism related.
Yes. Well, we only get to this second inquiry if you get over the hurdle of the first inquiry.
That, Lords, is the first point. The second point, Lords, is that there is an arguable conflict of authority as to this question at the High Court level. You'll hear more about this in due course, but the High Court's approach in this case is irreconcilable with the High Court's judgment in Tassib. Now, the court, of course, is hearing an appeal from Tassib tomorrow, but the question of law that arises in this case does not arise in Tassib.
Well, it doesn't arise yet, but they're actually going to have another hearing about whether or not the question of law arises. As I understand Tassib, I did want them joined, but you both said no, under no circumstances should they be joined. But Tassib does raise, or will raise in due course, whether Constable J's decision is to be followed by them, subject to what we say.
Yes, so the appeal in Tassib that you're hearing tomorrow does not raise this point.
No.
There is, Lord is absolutely right, an application for permission to amend the grounds of judicial review that the High Court will decide in October, I'm told, after the judgment of this court in this case. And the fact that at this stage there are at least arguably two inconsistent decisions of the High Court, in my submission, makes it more desirable for this court to intervene and decide the point one way or another.
Right. I mean, we can obviously spend time looking at this, but even if we were to conclude that what Mrs. Justice Farby had so far said wasn't flatly contradictory to what Mr. Justice Constable has said, your position would be that they hadn't so far at least taken the same position demonstrably.
Yes.
And so there is some doubt about the approach
yes.
that might be taken in the High Court.
The third point, my lords, is that FD is, as the court can see, represented before the court and is protected in costs. The costs order made in his favour below shall stand, and pursuant to an order made by my Lord Justice Lewis, irrespective of the outcome of this appeal, the Secretary of State will bear her own costs and will also pay FD's costs of the appeal. For that reason, Malone Friends for FDs seek to fully participate in the proceedings. They have provided a detailed skeleton argument on merits and will address the court in support of the judge's construction and will oppose the Secretary of State's appeal. The court will receive assistance from both sides in deciding the issue of law. The fourth point, my lords, is that this appeal is against a background of actual, not hypothetical facts. The facts, as the court knows, concern paragraph F, and the facts are not in dispute. The appeal involves a pure point of law of statutory construction. FD is now in the UK, and the dispute between the Secretary of State and FD that was subject of the judicial review claim in one sense is academic. But the point of law remains very much live, and the court can decide it. And fifth and final point, my lords, is directed to a submission that Malone Friends made in their skeleton argument. They submit that a judgment by this court would be, their words, a non-binding advisory opinion. That, with respect, would not be the case if the court decides to determine the question of law that arises in this case, receives submissions on that question of law, and decides it one way or another, then the court's judgment will be binding. It would not be open to any lower court to sidestep the court's judgment by simply saying that it's arbiter or merely advisory. For these 5 reasons, my lords, I respectfully invite you to hear the arguments on merits and decide the question of law that arises.
I don't know whether it's wrapped up in one of your reasons, and I'm not expressing a view about the merits of this overall submission, but the sort of issue that we have in this case is one which is likely to arise in a crisis with refusal of travel, and so it's hard to see how one can replicate a system, replicate a situation which can be easily dealt with at this level, arising from the sort of facts that are likely to be challenged when an ATC decision is taken. So maybe another way of putting the things that you've been saying is that we have here a case which brings forward the issue,
yes,
at a time of relative tranquility, whereas in real life those moments of relative tranquility will not be found again, and there's no knowing when they will come up, whether in Tasib or may or may not, at least for some time.
Yes.
And
so it's an opportunity.
And there's a case called Brooks at first instance, which my lord has approved, where that happened. It was interim relief for people urgently needing accommodation.
Yes.
And then you moved on, and there was never going to be a chance to have the interim position looked at again.
And I think I also, I mean, maybe, I think I'm right to say I also gave a judgment in a case which we can find about your 5th point, which is to do with whether something that has been decided, although academic,
yes,
is thereafter binding. And I think I said in terms that these are two completely separate matters, that if the court decides to go on and decide something which it could have decided not to decide,
yes,
that it can't be heard afterwards. People can't be heard afterwards to say that you can ignore it,
yes,
because it was decided, although for the individuals involved it had become academic. So I think there's some authority which, if necessary, we can look at in support of your 5th point.
absolutely. I mean, this court has said so in several authorities, but the proposition in my submission is so
Yes.
so
But I mean, we're all familiar with the Salem line of cases, but I'm talking here about what the consequences are if, following the Salem, the court decides to go ahead and deal with an issue which it could duck. That has no effect on the authority of the decision that it takes if it decides to take one.
Maybe Eld and Devon County Council.
Yes, that's right.
Does that ring a bell?
Yes, that's right. It was a special needs case where shortly before the appeal came on, the case had settled. Indeed. But it was a situation where it was not likely to arise again.
Yes.
for some considerable time.
Yes. So, my lord, in this situation, an appeal to this court, in my submission, is sort of unlikely to arise if a judge below grants interim relief and allows the passenger to enter the UK. It can arise in the circumstances where a judge below concludes that the judgment of Mr. Justice Constable is plainly wrong, declines to follow it, declines to grant relief, and the appellant, the passenger, then brings an appeal to this court, which may or may not happen for many months or years. As my lord observed, there is a live case before the court. Both sides are ready to address the court on merits. The question is of some importance, and the court should decide it.
Well, we'll obviously listen carefully to anything Mr. Gill wants to say about this subject, but clearly we're going to go on and consider your next rank of submissions, and then we'll decide, probably after we've heard both cases that are listed this week, what to make of the submission in relation to academic issue.
I'm grateful. So I'll therefore move on to the appeal. What I propose to do, again, subject to any observations, is to take you to the relevant provisions in three statutes in a chronological order: the 1971 Act, the 2007 Act, and then 2015 Act. So, my lord, in the authorities bundle, behind tab 2, you have section 3 of the Immigration Act 1971.
Yes, I'm sorry to be grumpy, but the electronic authorities bundle in this case is hopeless. It has no tabs, or at least only has 2 or 3 tabs, and you're going to have to give me page numbers for everything as you go along.
No tabs in the hard bundle either, so page numbers would be good for everyone, I think.
I've got tabs in the hard.
We've got tabs.
Yeah.
So can I, while we're being grumpy with whoever put the bundle together, just reverting to my past life, we did issue guidance which made clear that the way to do bundles is to put the authorities in chronological order.
Yes.
It's not helpful to have them divided up between High Court, Court of Appeal and Supreme, because you want to see the development of the case law. Not what particularly matters in this case, but since I've got you here, and since the government legal department, who probably did this, or maybe somebody's chambers, will be doing this regularly, could the message get back, look at the Court of Appeal guidance as to how to do authorities bundles?
Indeed. So may I apologise at once for what has happened. So the original, there were problems with the original bundle that was filed 2 weeks ago. There were no tabs, there were issues with the tabs. But that problem was rectified last week when proper bundles were filed. Of course, they have not reached my Lord Justice Lewis and my Lord Justice Peter Jackson for whatever reason. So I will refer to you to relevant pages.
Thank you.
So tab 2, which is page 8 of the bundle. You have section 3 of the Immigration Act 1971, the well-known provision. This provides a broad discretion to the Secretary of State to grant leave to enter or remain to a person. A person shall not enter the United Kingdom unless given leave to do so, and he may be given leave to enter or remain for a limited or indefinite period. This is subsection 1, A and B. So this broad discretion is subject to one qualification. If you go to the next page, page 9, you will see subsection 5, and you will see that this concerns deportation. And the Secretary of State can deport a person if the Secretary of State deems that deportation is conducive to public good. In other words, deportation is in the public interest.
Sorry, just pausing there, there's something I was going to ask. It's very natural, and you may well be right to say conducive to the public good and in the public interest are the same thing. Has anyone ever said that in case law?
Well, the statute now says that categorically.
Oh, does it? Well, you'll take us to that, will you?
Yes, so it's section 117C1.
But that's specifically in the context of deportation? No.
Yes, it says deportation of foreign criminals is in the public interest.
It's not quite the same point I was asking.
I see.
I was just saying, is the phrase... I thought that 117C said... Well, 32 of the Order Act uses the phrase conducive to the public.
Yes, I'll take you to that. That actually uses...
Okay, well, anyway, you're saying, and I'm sure you're right, but I just hadn't bottomed it out, conducive to the public interest is authoritatively glossed as the same as... Sorry, conducive to the public good is authoritatively glossed as the same as in the public interest. Is that right?
Yes.
What about necessary in the public interest?
Well, no, necessary is a different word.
Okay, well, that's helpful. Thank you.
And just one further question. It talks about liable to deportation from the United Kingdom. If you're in the middle of the process, you serve the stage 1 decision, but you haven't yet made the deportation order, and the person leaves, are you able to make a deportation order when somebody has left the United Kingdom, or must they physically be here?
They must be physically here. So once you have left the country, then you cannot make the deportation order. The way to address the problem is to make an exclusion order.
If you can do so, yes.
Yes, which is effectively, which has the same effect as a deportation order in respect of someone who is present in the UK.
And you're going to take us to the provisions about exclusion, are you?
No.
Where are they?
Well, they are elsewhere in the statute, but this...
You are an encyclopedia of all this, Mr. Mallet. You can just tell us, I'm sure.
Yeah.
Where it's... I'm teasing, but I actually wouldn't be surprised if you did know. There's a separate set of statutory provisions about exclusion orders.
Yes, so that is dealt with in the immigration rules. Previously, part deportation of the immigration rules, which also dealt with exclusion. Now they are set out in what is called appendix suitability to the immigration rules.
But that's a big issue tomorrow, actually, is whether there is a power under the rules or under statute to exclude Commonwealth citizens. You certainly have powers, it's thought, to exclude aliens who are not Commonwealth citizens.
Yes.
I can't remember what Mr. FD is. I thought he was a national of Jamaica, but I've forgotten now.
Yes, Mr. Tassib, one argument that you'll hear tomorrow is that there is no power to exclude Mr. Tassib because he's a common law citizen.
Commonwealth.
Commonwealth citizen, and controversial topic, and you'll hear more about this tomorrow. But that's not an issue that arises in this appeal.
Yeah.
So what is the effect of a deportation order? That is dealt with in section 5 of this act, which you have at page 13 of the bundle. So this is essentially a qualification to section 3.1 bar of the Secretary of State. Section 3.1 says that the Secretary of State can grant leave to enter or remain to anyone. But section 5.1 says that if the Secretary of State makes a deportation order, then that will invalidate any leave to enter or remain in the UK.
I'm so sorry, I'm going too far. Section 5...
Section 5.1.
Section 5.1. Yes, we haven't got the whole of Section 5 here, have we?
At page 13 of the bundle, you have Section 5.
Yes, but it stops at the bottom, but it doesn't. We haven't got the rest of the section. It doesn't matter. I was just surprised, because normally you reproduce the whole of the section. Anyway, that's fine. I just want to make sure there wasn't a mistake. Yep. You're talking about Section 5.1.
Yep. Simply subsection 1. If the Secretary of State makes a deportation order, that automatically invalidates a person's leave to remain, and any grant of leave while the deportation order is in force will be invalid. So it is not in the power of the Secretary of State, in other words, to grant leave to enter or remain to someone who is subject to a deportation order. if there is a grant of leave, then that, as a matter of law, will be an invalid leave. So this is the 1971 Act. If you then go to page 120 of the bundle, which is tab 19.
So sorry, I was being slow. Where are we going?
It's tab 19.
Yep. Thank you.
Page 120. This concerns automatic deportation. And Lords will see that subsection 4 refers back to section 3 and says that deportation of foreign criminal is conducive to the public good. So this is Parliament saying categorically that deportation of foreign criminal is conducive to public good. And the Secretary of State is obliged under subsection 5 to make a deportation order in respect of foreign criminal. So in other words, Parliament placed an obligation on the Secretary of State to make a deportation order which in turn will invalidate the person's leave to enter or remain, and which bars the Secretary of State from granting that person leave to enter or remain. So this is the 2007 Act.
Well, you've got 6 as well. He may not revoke it unless he thinks that an exception applies. So there is the possibility
Yes.
of revocation.
Yes, indeed. That where the exceptions would apply. The exceptions are at page 121. Essentially, the first exception is where deportation would breach someone's convention rights or the obligations under the Refugee Convention. And the second exception concerns the date of the foreign criminal.
These are, again, incomplete. I thought there was a provision saying you can make a deportation order even if an exception applies, but you can't give effect to it. But
Yes.
for certain cases, you can't even make the deportation order. So we don't seem to have a full set of relevant provisions here.
No, that, my lord, is dealt with elsewhere. Dealt with in another part, which is
We haven't got section 34 here.
It's not in the bundle.
No, but section 34 is quite important, isn't it?
Not
We have got section 34.
Yes, not for.
It's at page 122.
Is that the whole
Very
section?
Oh, I haven't got a page 122 in the bundle, that's why. Don't worry, I'll get it at lunchtime, I'll get the act.
Lord, I'm so very sorry. It was last Wednesday when the revised corrected bundle was.
Don't worry, I normally bring Feeling Gillespie, but I've left them at home, but I'll bring them in after lunch. But,
Yes.
so you have section 34, which, my lord, you do not have.
yeah.
But it matters not in my submission for the purpose of the argument that I'm seeking to make. It's not controversial.
Yes, we haven't actually got the, which again is what you're supposed to do, we haven't got the as it were, the title page of the statute, which enables you to see how the sections group together. And I think somebody just needs to think about this for another time, because it's a snippety approach to statutes. We won't even do the whole section. We'll just do the sections that we're sidelining. We don't think like that. We like to see the full context. Anyway, sorry.
That is done. The short point to which I thought I would show you these provisions before looking at the 2015 Act is to make the point that Parliament has said that deportation of foreign criminals is conducive to public good, and if the Secretary of State makes a deportation order, that invalidates a person's leave to remain and bars an applicant from returning to the UK.
Just remind me, does he have to make it if it's a conventional right exception, or does he have to make it but it can't be enforced?
The Secretary of State has to make the deportation order, but it cannot be enforced. The position is if there is a convention reason.
I'm not saying you're right. I'm sure. It's not what it says here. He must make a deportation order subject to Section 33.
Yes.
Section 33 says that Section 32(5), which is the one imposing that obligation, do not apply. So it suggests that you didn't have to make an order where Section 33 is engaged. I haven't, my Lord knows much more about this than I do, but I wasn't familiar with the concept of making an order but it being unenforceable.
Well, I haven't got subsection 7 which will tell us, I'm guessing.
Yes.
What does subsection 7, give me a clue, go on. What does subsection 7 says? Because that's the, it looks as if subsection 33(1) says you don't make it at all. And then I thought there was a provision that said you can make it in a small class of cases. But
yes.
Subsection 7 has been cruelly withheld from me. I just can't remember it.
My apologies. So again, with this fact, if I may just park the question that is troubling Lords, I'll give an answer that is accurate.
I can tell you what subsection 7 says if it helps at this stage.
Yes.
Subsection 7 says that the application of an exception, A,
yes,
does not prevent the making of a deportation order. B, results in it being assumed neither that deportation of the person concerned is conducive to the public good, nor that it is not conducive to the public good.
So it tells you...
But,
wow.
Subsection 32(4) applies despite the application of exception 1 or 4.
That sounds as if you don't have to make a deportation order, but you might be able to, which is rather different.
Speaking for myself, I'd certainly like to see subsection 7, at the risk of being a bore about this. I wish the whole section had been introduced in the first place.
But I'll provide that to you. Indeed, there is of course case law on that. But may I very happy to assist, my lord. So it's just that isn't an issue in this appeal, and the reason why it's not an issue in this appeal is because it's common ground that the Secretary of State made a deportation order in relation to FD.
Had he ever served it on FD? I thought there was something on the file, but
yes,
part of the problem was poor FD never even knew about this.
Yes.
So I'm not sure that a valid... I just can't remember reading the facts again now, that there had ever been a thing that was legally a decision, because there might have been something on the file, but nothing had ever been done to send it to him.
Not I will show you the relevant part of the judge's judgment where he says something about the deportation order. But again, it matters not to the argument that I'm seeking to pursue.
All right. Where to next?
Then, straight to the provision that is at the heart of this appeal, which you have at page 141. page 141, it's tab 28, where you have the relevant provisions of the 2015 Act. If you wish to see the table of contents, the provision, unlike other cases, we have that here at page 149.
149, so not at the front.
No, not at the front, I'm afraid.
Yeah, that looks like the Westlaw thing. I mean, it's fine. It's not. Anyway,
So this
okay, thank
will
you.
tell
Yeah.
you different parts and schedule.
I want the whole thing just to be safe.
Right, so back to 142, is it?
Yes, so 142, you have section 22. And subsection 1 tells us what the authority to carry scheme is. That is a scheme requiring a carrier to seek the Secretary of State's authority to carry a person on aircraft, ships, or trains. And subsection 2 provides that the scheme must specify or describe A, classes of carriers to which it applies, B, classes of passengers or crew in respect of whom the authority to carry must be sought, and C, that is relevant here, classes of passengers in respect of whom authority to carry may be refused.
When there's a reference to making one or more schemes, is that intended to cover what's happened in this case, which have there been sequential schemes? Or is it contemplated that there might be several schemes operating at the same time?
Well,
or both?
It contemplates the Secretary of State setting up different schemes operating at the same time.
And has that in fact happened?
No.
No, so in fact what there have been is there's been one scheme which has been revised twice.
Yes. Yes. And the statute deals with that situation about revision of the schemes in a provision that I'll take you to. So the Secretary of State is placed under an obligation to specify or describe classes of passengers in respect of whom authority to carry may be refused. And you then have subsection 3, the authority to carry scheme may specify or describe a class of person under subsection 2C only if it is necessary in the public interest. And this bill is all about the words, it is necessary in the public interest.
And what it is necessary, what has to be necessary in the public interest, is to specify a class. It's not about individual decisions. It's about, well, I mean, it doesn't matter in English. It says the scheme may specify a class only if it, that is to say the specification of the class, is necessary in the public interest. Is that the right analysis?
That is the right analysis, yes. What the judge below, in my respectful submission, has done is that he, with respect, distorted the clear statutory language. Effectively, he replaces the words, if it is necessary in the public interest, with, if they pose a terrorism-related threat. Another way of putting the point is that the judge added the words of prevention of terrorism at the end of this provision. The provision says it is necessary in the public interest. The judge read it as it is necessary in the public interest of prevention of terrorism. the submission, my lords, with respect is that there's no justification for reading the statute in that manner and inserting words that do not exist. If you then look at subsection 7, you'll see that it makes the obvious point that the grant or refusal of authority under the scheme does not determine whether a person is entitled or permitted to enter the United Kingdom. So in other words, the Secretary of State retains the power to grant leave to enter or remain to someone. And the scheme is that a grant of authority does not mean leave to enter.
But it doesn't mean an existing leave to enter is invalidated. So if, in fact, Mr. FD had been validly granted indefinite leave to remain, he would be allowed to enter. Mr. Tasib had definitely been granted indefinite leave to enter and remain. So those existing rights were preserved. And you're saying, in addition to that, the Secretary of State could grant somebody who hadn't got leave already, leave to come in on a different occasion, albeit that it stopped him coming on the first flight. That's what you're saying, is it?
Well, yes. And one of the other points, the basic point is that it is the Secretary of State, a different decision maker, that decides whether to allow a person to enter the country. If a person has existing leave to remain, the Secretary of State may stop that person on arrival, may cancel that leave.
Yes, but unless the Secretary of State does that, he can turn up. So if you stop Mr. FD on the Turkish flight on Tuesday,
yes,
and he hopefully turns up at the airport on Wednesday,
yes,
and there's no ATC, he will be able to travel to the United Kingdom, and absent a positive cancellation of his right,
that's right,
he would be able to enter.
Absolutely. Absolutely. So if, for example, a person is traveling from France, there's no authority for the airline, the person takes a train or a ferry, which, in respect of which there isn't a refusal to carry.
So somebody can keep trying, is the point.
Yes.
They can keep trying.
I can see that's how it would work in those situations, but I understood it, tell me if this is wrong, simply to make the basic point that what you're doing here is a different kind of exercise. Leave to enter and leave to remain are governed essentially by the immigration rules, which have their own procedures. Where you deny authority to carry, that's all as well without prejudice to the ordinary procedures. And I thought that was probably all it was put in to do, because that is actually quite an important point to make. How that plays out in particular situations is another matter, but the draftsman was probably just thinking of that, weren't they?
Yes, I mean, I accept that. Yes, that is the point. Yes.
But how, in practice, if you're in Turkey, will you, if you've got an existing leave to enter, be able to exercise it? Because every time Mr. Poor FD goes to the airport and turns up hopefully at the check-in desk, a smiling receptionist will say, "Lovely to see you, but we've been told not to take you." How is it going to work in practice if somebody has a leave, but you've decided to put him on a list which says, if you get a request, refuse it?
In practice, it would be quite difficult for the person to return to the UK. That is the whole point of the scheme.
Yeah.
But the submission that I'm making is, as my lord pointed out, is simply a broader point, that there are two distinct decision-making processes that the statute.
I mean, the point is not so much that not just that it will be quite difficult for someone to get back, but that the Secretary of State might be expected to exert every effort in preventing the person from coming back. It would simply be a question of whether they could beat the system that was being ranged against them.
Yes.
In practice, presumably what you'd have to do if you had the money and the know-how to do it, is the obvious thing is you ought to go to the Republic of Ireland and across the border.
Yes. Yes.
Sorry, am I saying something I shouldn't have said? But I mean, I'm just because anything else involves going on a boat, a train, or a plane, and those are the only three ways of getting across the sea.
Yes.
Or under the sea.
Indeed, but there are, as my lords would know, hundreds of different airlines flying from different jurisdictions, different countries, and
I see.
Basis. So it is.
But if the system, okay, you could strike lucky.
Yes.
We haven't really had any information. I'm not sure we need about how the system works. The system is meant to be universal.
Yeah.
Any airline flying into the UK is meant to do the check. It's presumably all computerized. They submit the manifest.
Yes.
And they get a bounce back for those who.
Yeah.
So, as you say, of course, the system there might be loopholes through error, but otherwise, you've got to come by land effectively.
Yes.
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 Well, out of curiosity, does it affect Eurotunnel as opposed to Eurostar? You don't know. If you turn up in a car,
I mean, that's that would be. Would still be trained, I suspect.
Well, I don't know.
The intellectual problem you've got is this. You're trying to work out necessary in the public interest. You know that this doesn't invalidate a grant or prevent the grant. So if you have somebody or a group of people, those with indefinite leave to enter and remain, and that's what they've been allowed to have, and you haven't taken steps to cancel that, how can it be necessary in the public interest to keep people out of this country who have a right to come into the country? Is that a limitation on the necessary in the public interest?
Well, that phrase, Lord, is directed not to one particular person, but to a class of person under subsection 2C. A class of person.
But can you include as a class of person? Can it be necessary to keep out that class of person, those persons with indefinite leave to enter, which has not been cancelled? How can it be necessary in the public interest?
So I just didn't hear my Lord's question. Necessary
in the public interest to keep out a class of people comprising those with indefinite leave to enter and remain, which hasn't been cancelled.
Yes.
That's how I'd understood from Mr. Yetman at the permission stage that 22.7 might impact on the scope of 22.3.
Yes.
If you haven't invalidated the class's leave to enter, how can it be necessary in the public interest to grant them to grant an ATC to stop them exercising that right?
Lord, I can see an argument that that would not be necessary in the public interest, and if that happens, then there would be a judicial review claim challenging the legality of inclusion of such class within the scheme.
You say it doesn't apply to F.
No. Does it apply to any of the? Does it actually? Do any of the heads of 14 the scheme actually made cover my Lord's class?
So
Maybe.
yes. The scheme.
I mean, I haven't myself worked through all these heads, so some of them are very arcane, some of them are pretty obvious.
It's page 165 of the bond.
Sorry, I've got it loose, but I mean, K is a borderline case. There are people who have entry clearance. There is a bit of paper that says entry clearance, but the Secretary say has reasonable grounds to believe it's false.
Yes, one.
And then J is a variant on that. I'm not sure that the Secretary of State has purported to give herself the power to refuse authorization in the case of someone who has a valid entry clearance.
If you look at AF,
that is,
people who are subject to deportation order are fine because the deportation order cancels it. But it goes on to include those in the process of making the order, your stage 1, and their leave to enter has not been cancelled. And 2 of these cases involve situations where there might have been appeals or representations, and they haven't had their leave cancelled. And the question is, can they be within a group, and are they within the group? 2 separate questions.
yes.
Because that'll answer whether they can return to continue with the process and have an appeal. You follow me?
Indeed. So, of course, you'll hear more about that. But
Yes.
if you look at perhaps just giving, just bearing in mind the example that Millard gave. So, GA concerns a person who is given indefinite leave to remain, but where indefinite leave to remain has been revoked under Section 76. So this is where the Secretary of State has revoked leave. But one can contemplate a scenario where a person will have indefinite leave to remain, and the Secretary of State may still refuse authority to carry. If you go to the next page, page 170, you'll see, for example, where the Secretary of State.
I'm so sorry because I'm looking at loose. Which paragraph is this?
So page 170, J, where.
Sorry, but this is 14, paragraph 14.
Yes, paragraph 14J, yes.
But that doesn't have, that's people who've been refused leave to enter. That's presupposing they haven't got it and it's been refused before they leave the UK or in the course of their journey.
Yes, J, my lord.
J, sorry, not
Yeah, J, my apologies. So,
yeah, they're using an invalid travel document.
So a person may have indefinite leave to remain, but an invalid travel document, or where if you look at K, where the Secretary of State has reasonable grounds to believe that permission or endorsement is false, or there is an unauthorized.
Well, can we stay with your J example for the moment and consider a person who has indefinite leave to remain, but who has left the country and is seeking to return on an expired passport?
Yeah.
That case would crisply give rise to the point that my lord started making about whether it could be said to be necessary in the public interest that a person of that kind should be certified, that class of persons should be certified. Would it not?
Potentially, yes.
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 And so then going back to our own F, the question arises about whether somebody who has indefinite leave to remain, but the Secretary of State is in the process of making them the subject of a deportation order.
We're basically asking you to just argue tomorrow's case.
Yes, but I mean, as we're scoping this out, the question may not arise in relation to somebody who is subject to a deportation order, but it might be somebody who is just coming within the crosshairs.
Yes. Yes, but the issue, of course, in this appeal
is somebody who is the subject of deportation order.
A prior issue is whether it's simply terrorism related, or it is terrorism related plus other.
That's
matters.
the issue for today.
That is the issue for today. And Lord is absolutely right. One can contemplate many scenarios where it could be possible to challenge inclusion of certain classes, certain individuals within the list. But the question for this court at this hearing is whether the statute limits this to terrorism-related threat or not. So, Lord, can I just show you just one other statutory provision and then we'll focus on the scheme, and that would answer the point, the question that Lord Justice Peter Jackson asked about the Secretary of State revising a policy, essentially issuing a new policy, new scheme. So that is dealt with under subsection. That is dealt with under section 23, which you have at page 143 of the bundle. So you'll see that that section concerns how the scheme comes into force.
I'm so sorry, I was just making a note. Where? Which
Yes,
page?
Lord, if you go back to tab 25, page 143.
Thank you.
One argument you don't seem to be making, just to check that you're not making it, other parts of the Act which aren't included in the bundle, Section 2 provides for the making of a temporary exclusion order, and that has conditions, and the Secretary of State can't make an order unless he reasonably suspects that the individual is or has been involved in terrorism-related activity. So there are some parts of the Act where they use the phrase terrorism-related activity, and Section 22 doesn't, but you've not relied on that, so that's a bad argument, isn't it?
No, my lord, that was the next point on,
Was it? Oh, right.
on the list, but I was hoping to show you a different provision that makes the same point.
Oh, right, okay, go on then.
But may I just first show you section 23, which concerns how the scheme comes into force. My lords know that is by way of regulations made by the Secretary of State. There is a positive resolution procedure, and if you look at the next page, subsections 3 and 4, you'll see that the Secretary of State may revise the scheme by way of a statutory instrument, and again there is a positive resolution procedure. And then just to pick the point that my Lord Justice Lewis made, if you look at page 141 of the bundle, this is just one of the several examples. You have section 1 of the 2015 Act.
So sorry, before we just get there, I just wanted to make sure I bottomed out. So 23 gives the power to make regs,
Yes.
which embody or give effect to a scheme. The regs in question, perhaps you're going to come to them, but they're the ones at tab 29, the authority to carry steam civil penalties regs 2015. Is that right?
This concerns the penalties that.
Okay, where are the actual regs giving effect to the scheme?
I think they're at 156. It's tab. Oh well, okay. I'll tell you.
I've got that. That is. Well, that's the one I was asking Mr. Malik about, and that is about the penalties. And I just hadn't bottomed out. Presumably, there's some regs somewhere say, pursuant to Section 23, we schedule a scheme. So, yes, no.
Regulation 2.
Yes. So.
Regulation 2 is just an interpretation.
Yes. So yes, indeed, there are.
You'd think the scheme would say somewhere.
Yes, I wonder whether there's a different set of regulations, but it seems.
There must be a different set, because this is for Regulation 24, the penalties.
Well, that's just what I wanted to bottom out. And oddly, the scheme, when you looked at it, I'm afraid just printed it out from the website, so I know, but it's the same as it appears here, doesn't actually identify the regs under which it's made. Or if it does, I can't see where.
24(7), under Section 24.
Section.
The 156 regulations are under a section we haven't been shown yet, which is you can penalise the carriers if they let them on anyway.
Yes.
And this is to do with the penalties for the
Yes.
carriers, I thought.
Yes.
Yes.
So
Well, unless you tell me otherwise, it looks as though there hasn't been included in the bundle, which I think it could have been. the regs under which the scheme is made, or not under which, the regs which make the scheme, presumably by form of some sort of schedule. I don't know, we haven't seen it, but that's how you expect it to be done.
Yes.
Could we have those?
Indeed, I'm just checking the answer to that.
Maybe the whole thing is in lawful.
Yes. Yes, my Lord.
Well, you've got a Hansard debate suggesting otherwise, but
15167, we shouldn't really be trying to get to the bottom of this, Mr. Malik, but 167 starts by describing the scheme, and one would hope it would cross the mind of somebody to realise they need legal authority to make it.
I'll find the answer to that question. If there are separate regulations,
but there must, just to be clear, I may have misread it. It just occurred to me when I was looking at section 23(1), an authority association comes into force in accordance with regulations made by the Secretary by statutory instrument. So there must be regs which say the authority to carry scheme 2023 or 2015, whatever date it is,
yes,
comes into force.
yes.
And in practice, you would expect it to be attached or exhibited or scheduled in some way.
Yes.
Because otherwise you wouldn't know what it was referring to. So you're saying that if there are any regs, there must be.
There must be, yes.
Otherwise, it hasn't come into force. It's not that it's invalid. I'm quite
Well,
wrong.
I'm just seeing how much we can get out of Regulation 2 of the regulations we have been given, which is at 157 again. That if you look at the date of 9th of January 2023 and then at the footnote, word substituted by 2023-326.
Ah, yes.
And this is in fact 2019. We're reading out of 2015-957. So we probably need to be provided
yes.
with 2023-326, don't we?
Lord, I will provide the 2023 statutory instruments, regulations by which the scheme is.
And it may be necessary, I'm not saying it will, but it may be necessary, they may cross-refer to the 2025, sorry, to the original regs, the 2015 regs, which, as you say, are probably not the ones we've got, which seem to be only about civil penalties.
Yeah.
So, yeah.
Both. So, my Lord, just picking up a point that my Lord Justice Lewis made. So, I have shown you the 2015 Act. If you look at Section 1 of that Act, which in the bundle you have at page 141, you will see that
Yes, Nicholas.
My Lord,
Right.
my Lord has found.
Well, just to reassure ourselves, they do exist.
Right.
Yes, sorry, I interrupted.
Yes.
Your reference.
Page 141, where you have Section 1 of the 2015 Act. And my Lords will see that that uses the words in connection with terrorism-related activity. So when Parliament intends to limit a power by reference to terrorism-related activity, we know from the statute that this is the sort of language it uses. I ask you respectfully, my Lords, to compare the language that is used in Section 1 with the language that is used in Section 22(3). That, in my submission, is yet another reason why it is wrong, in principle, to read in the public interest as terrorism-related activity.
And my Lord has already pointed out, he's got the full thing, that you will find the similar language in Part 2.
Yes.
So you can seize passports of people suspected of terrorism-related activities,
Yes.
and that the power does not go wider
Yes.
under this act.
Yeah, indeed.
And it's the same for exclusion orders, which are arguably more analogous in
Yes.
Section 2, which we haven't got. That says you can make an exclusion order for somebody reasonably believed to be involved in terrorism. Not you can make an exclusion order where it's in the public interest.
So if one compares the statutory language, in my submission, it becomes clear that in the public interest is a phrase that has different meaning as compared to terrorism.
It'd be useful if we explore Section 2 as well. I know
Yeah.
my Lord already has, but for those of us who haven't.
So Lord, this is the statute. Lord, you have looked at the ATC scheme already. It is. May I just take you back to that scheme, page 165 of the bundle. But before one looks at paragraph 14 in my submission, it is relevant to look at the text that appears earlier in the scheme. If you look at page 167, and if you look at paragraph 2, this provides the context of the scheme. And you'll see that the third line says that there is a need to prevent or disrupt the exit from, entry to, or return to the UK of individual who pose terrorism-related threat. But then it goes on and says, or other threat to the UK or its interests.
I'm sorry to keep bombarding you with questions, but it is a question of statutory interpretation. So we need to know why this other document, which is a scheme, is relevant to the interpretation of a statutory provision. There are cases that say if it's made contemporaneous with an act and the act contemplates that there be regulations, as that may be relevant, or there may be other principles. So are you going to show us why we can rely on this when we're interpreting the parent statute?
Lord, I'm not asking you to construe the statute by reference to the scheme.
Ah, right.
I'm asking you with respect simply to construe the statute by reference to the words that are used in the statute. The scheme is simply an illustration of the way in which the power has been exercised. So the question,
the illustrator is meaningless, isn't it? I mean, you do have to say, well, I don't think this is the attack on you, but you do have to say not only that you're right about the statute, but that the scheme that was in fact made went wider than terrorism-related activities. But
yes,
this clearly shows that it did.
yes,
But it can't help you on construction, and I think you're accepting that.
yes.
To say it's an illustration is a bit, I mean, it's rudely a bit weasel-worded.
Yes.
But my Lord is right, isn't he, that there are cases, if the first scheme used the same language, one way back in 2015, there is some case law, the case comes to mind called Packard, I think,
Yes.
which says, purists like me are a bit puzzled by this, but it does say, the Supreme Court does say, that secondary legislation introduced effectively at the same time, or was in gestation at the time that the primary legislation was introduced, can cast light on the meaning of the primary legislation. Is that it's even in Latin? Is it called contemporanea expositio? Maybe it isn't. But do we have the 2015 scheme? Does that have the same language?
No, I'm not making that point.
Okay.
And the earlier schemes had different language.
The schemes have grown
Yes.
each time, haven't they?
So different languages used. I'm placing no reliance on the language of the scheme in my submission about the construction of the statute.
So for the purposes of your appeal, this is interesting but completely irrelevant.
Well, the question of the statute for the court is whether in the public interest means terrorism-related activity. The submission is that it does not mean terrorism-related
Yes, and
activity.
it's not in dispute that within the scheme there was paragraph F, which covered a person subject to a deportation order. So but in a sense, we can interest ourselves in the scheme if we want to, but it doesn't affect the issue.
Well, subject to one point, which is that you will now look at the judge's analysis. One reading of the judge's analysis is that he said that the scheme even is limited to terrorism-related threat.
Okay.
But that is one potential reading.
Right. So you're using this excursion into the scheme as a shield rather than a sword in relation to your your statutory interpretation. Okay. Well, shall we stop interrupting you and actually
so I have shown
see what you said?
I've shown you paragraph 2.
Yes.
3 and 4 are obviously related to exclusion and deportation. And paragraph 6 essentially uses statutory language. The purpose of the scheme says, paragraph 6 says, is to prevent certain individuals from travelling to or from the UK when it is necessary in the public interest. You have seen paragraph 14 already. The language in my submission couldn't be clearer. Absolutely clear that it's not. Paragraph 14 is not limited to terrorism-related threat. Paragraph F has nothing to do in my submission with a terrorism-related threat. It allows the Secretary of State to refuse the authority in respect of a person who is subject of a deportation order, or where the Secretary of State is in process of making a deportation order. So this is the scheme, and can I then show you the judge's analysis and reasoning? So in the core bundle, have the judge's judgment at page 80. There is a heading textual background at page 82, and the facts summarized by the judge are uncontroversial. So I would respectfully invite you to essentially adopt those facts. If you look at paragraph 8 of the judgment, you will see that the judge sets out uncontroversial facts that there was a stage 1 deportation order. Secretary of State wrote to FD inviting to provide reasons why he should not be deported. He made a human rights claim, and despite this, a deportation order is issued on 12th of May 2017.
He doesn't say, paragraph 8, what the conviction is for, or for how long it was. Is there some good reason for that, or is there no secret about that?
No. So the conviction is for possession of ammunition, as the court knows. The sentence is 7 years and 4 months.
Yeah, thank you. And when was the sentence imposed?
Sentence was
2015.
It was about 11 years ago, wasn't it?
Sorry, I'll just.
I saw reference to this somewhere, but I didn't. I was surprised not to see it in the judgment.
Why do I do that?
It was 2015.
That is 2015.
Yep. Thank you. Okay.
So the judge says that a deportation order is issued on 12th of May 2017, and I will address you, but I thought there was no issue in this case that a deportation order was issued as the judge says on 12th of May 2017.
Well, it was withdrawn then, though, if you look at the rest of that paragraph. But I thought he'd made it again, perhaps. He issued a new decision. He made the decision before waiting for the representations. He made the order.
Yes.
That was withdrawn. There was a human rights claim, and that human rights claim failed. So you'd have an in-country right of appeal, which is the important thing. He didn't have to go to Jamaica to make it.
Yes.
And then he was on bail. I can't see in this where he's made new order.
Well, the decision that was withdrawn, Lord, to my understanding, was the refusal of the human rights claim, giving rise to an out-of-country right of appeal.
So the deportation order of the 12th of May stayed in force, and it was an application to revoke it then?
Yes.
Because you could do that then?
Yes, that is how I read those paragraphs, and therefore the deportation order that is made on 12th of May 2017 is the order that stands.
Yep, okay.
So, sorry, just so I make a note of this, you say what was the judge is referring to as having been withdrawn was the decision that any appeal would be out of country.
For the reasons that my Lord knows too well,
Yes.
of course, having dealt with those sort of cases.
Yeah.
The problem arose because FD made a no time limit application, and the Secretary of State issued a correspondence saying that he has indefinite leave to remain. And FD's case essentially was that there is a legitimate expectation that he has indefinite leave to remain. That correspondence was then replicated in the online eVisa. That was in error. The fact that there is a deportation order in place means that grant of leave to remain is just not possible. A deportation order invalidates a person's indefinite leave to remain, and while the deportation order is enforced, the Secretary of State has no power to grant further leave to remain. A grant of leave to remain would
You have to dismantle the deportation order first, and then grant leave to remain.
Then grant leave, but it matters not. The facts at paragraph 6 to 23 are uncontroversial. The judge's reasoning as to grounds 1 and 2 is paragraph 27 onwards. And
I'm just not, it's slightly unclear. There was definitely an application to revoke the deportation order, paragraph 9, and that, well, there was a protection claim made, and that was treated as an application to revoke the deportation order. So I just don't know what happens when there's an application to revoke or a further human rights claim. You don't give effect to it by definition. Presumably you can't send the man back to the country that he says is not going to protect him.
Yeah.
So what was happening after the 26th of November 2019? They weren't implementing the deportation order. So what status did he have here? Was he here lawfully or unlawfully?
Well, unlawfully for sure. So he was in a situation where a person's appeal has failed, and that person then makes further submissions or an application for revocation of the deportation order.
Right. So he's applied effectively for asylum, which is seen as an application to revoke, paragraph 9.
Yes.
So you can't remove him. You think he's got no leave to be here, but you can't remove him. Is that the position? Until the conclusion of his proceedings?
Yeah. Yes. So if a person makes an asylum or human rights claim, and then, but as a matter of practice, the Secretary of State would not.
Or, I mean, I appreciate the two are normally linked, they obviously were here, but in principle you could have an application to revoke on non-human rights grounds, couldn't you?
Yes, indeed.
Yes.
Yep.
Change of circumstances, whatever it might be. And you're saying that while that application is pending, the Secretary of State, as a matter of practice, will not take any enforcement steps. And that's not an unusual situation, that someone is not lawfully here technically because they have their leave to remain has been revoked, but they are irremovable until they will not be removed at any rate until the proceedings in question are over, until the question has been resolved.
Indeed.
And that's quite a common situation. He's presumably on immigration bail.
Yes.
Yes.
So yes. So a person is in immigration bail, or just to use the language.
Yes, I'm getting rusty on this. What is the official term for the status of someone who's on immigration bail and doesn't have leave?
So under the 1971 Act, the phrase was temporary admission. So the person wouldn't be granted leave to remain, but would be granted temporary admission.
I remember now, yes.
In the UK.
So what has happened here, reading on a bit, is he's got this application for protection, call it asylum, what you want, and that's being looked at, and the deportation order is not being given effect to pending the outcome of that.
That goes on for years.
Yes, and that goes on for about 10 years. But they completed that process, but they never tell him the result. So he doesn't know the outcome. He hasn't had a decision refusing his application. And at the same time, somebody else in the Home Office is actually giving him limited leave to remain, isn't it?
Well, that, my lord, appears to be a fair reading of these paragraphs. Appear to be what has happened. I mean, why that has happened is not.
Well, on top of that, he then gets an eVisa.
Yes.
Yes.
But no, yes, the NTL letter doesn't formally give him leave to appear to give him leave to remain. It simply says our records show you already have it.
Yes.
Wrongly.
Indeed.
Yes, and to follow
the eVisa probably is. Yes,
sorry.
It's the grant, yes.
No, but I mean, to follow it all through, one would have to track the supplementary bundle in some detail. But at the moment, we're just trying to make the best of the judge's helpful summary.
So eVisa is arguably a grant of leave.
but it's an invalid one.
It is an invalid one if it is a grant of leave. Yes.
Yes.
What? Because it comes up against the deportation order that has not formally been. Right. So it's a mess. It's a complete and utter mess.
Well, it was at one point, but it no longer is because Secretary of State has sort of withdrawn eVisa that no longer exists. And
Has he actually finally taken a decision on the human rights claim, stroke protection claim? Has he sent the letter that's been on file for 10 years?
That I'm afraid I don't.
We don't know. So we don't know. So what's happened to FD then? Is he still here? Does he have a decision on his human rights claim? Are you trying to deport him?
No, he has. There is a decision and there is an appeal that is pending.
He's got the decision now. So he's appealing the decision, is he?
Yeah, so
My Lord, I'll try to take you through the chronology in due course because it's rather complicated. But to answer this part of it, there was a decision they put on file in April 2025. Didn't give it to him, although it just needed a topping and tailing. He went abroad thinking he had ILR because they'd given him a letter saying you've got ILR and the eVisa. When he's abroad for 5 or 6 days, that's all he went for. He's then, as we know, stopped from coming back on 23rd of September. Then he starts contacting the solicitor here, finding out what happened. Solicitor contacts the Home Office. The Home Office then, on the 2nd of October 2025, top and tail that decision that they've had put on file but never served on.
So they served the decision dismissing the claim on the 2nd of October.
But they sent it to his home address in this country, although the landlord later took possession of it because the chap wasn't here and he lost his home and job and so on. It was served here, strangely suggesting that he had an in-country right of appeal, and we had comments to make about why they operated in that way, and the judge had some comments to make as well, that it's a remarkable coincidence, but he's not going to say any more than that.
But surely, I'm sorry, this is only just so I don't get lost. All this, I can quite understand why he's exercised about this, but none of this is for us to decide today.
Of course not.
Of
course not. I only stood up because there seemed to be some confusion about the chronology.
Yes.
I don't think this question is at all relevant.
So facts are not relevant.
The one thing I did decide to do was not give you permission on the facts.
On the
I did
facts,
once understand them, but that was now some time ago.
Indeed. So on the facts, there's no dispute that there's no appeal from the judge's decision that on the facts the decision was irrational. But I take no issue with that. So you have the sort of basic background facts in the judge's decision, and well, those are the facts that in my submission you will need to decide the issue of law. Now, the judge's analysis of section 22(3). So if you look at paragraph 33, this is where the actual analysis starts. Earlier in the judgment, there's simply a recitation of the statutory provision and the arguments. The judge there, in my respective submission, makes an error. So instead of starting with the statutory language, the language of section 22(3), the judge refers to explanatory notes and the scheme, and says that the whole object is prevention of terrorism-related threats. The judge should have started with the language that is used in section 22(3), but in my submission, it is not the whole object of the Act to prevent terrorism-related threats. It is one of the objects indeed. It can be said that, well, it is a primary object, but not the whole object of the Act and the scheme for sure.
Sorry, I'm just thinking about your submission that the judge started at the wrong point. We're on the page which has 31, 32, 33, aren't we?
Yes, sir.
Right. So he starts off at 31 by alighting on the right words that need construction. He refers to the competing construction.
Yes.
And he refers then to it being clear from the Act itself, the explanatory notes and the scheme are set out further below. So far so good?
Well, not paragraph 23, so there's no issue.
Not
with
paragraph?
Paragraph 33.
Right, that's the focus of your criticism.
Exactly, and
because, just say again, why is that?
Well, for two different reasons. First, the judge says that the Act, the notes and the scheme, the whole object of them was to introduce a mechanism for prevention of terrorism-related threats. But that surely is not the case. That wasn't the whole object of this scheme as a whole. That was one of the objects.
Yeah, I understand that that's your case.
That is
but I was just trying to understand what I understood to be your submission, which was that the judge went off the road right at the beginning by starting with the wrong. Now, he refers to the Act itself. You say that that's followed by large quotations, 34, 35 and so forth, from the introductory words,
yes,
from the summary and background of the notes, and so forth. In other words, what you're, to understand your point, you're saying he should have started with 22.3.
Yes.
And if he'd set that out at the beginning, that would have been the way in.
Yes. So
right, I've got that. Thank you.
So the focus in my submission was not on the text of the statute, but on external documents, and that was the wrong approach. So paragraph 35, paragraph 34, the judge refers to the introductory words of the 2015 Act. They obviously are not limited to terrorism threats as such. And then there is extensive citation from the explanatory notes and the scheme itself. So that, in my submission, reflects an error of approach. The starting point should have been the words of section 22.3. If there was any ambiguity in those words, then it might have been justified for the judge to look at the extraneous material.
So just another small point on which I'm getting rusty. What's the distinction between explanatory notes and explanatory memorandum? Are they just two names for the same thing? What's the state? Are these the notes that go to the Commons before the Act is enacted? I'm just wondering what their status is. I know that I used to have this. I used to have this
Fingertips.
at my fingertips, looking for the right phrase, but I don't anymore. There is case law about the status. You're not saying these are inadmissible as such.
Yeah.
Okay, they are admissible, but only it all goes back to that decision of is it the thing? Lord Hodge and all that.
Indeed. So if there is an ambiguity in the statutory language, or if a plain reading of statutory words lead to absurd outcomes, then it could be permissible to look at the notes and other documents. But in my submission, not this case. Now, if you then look at
Sorry, good. Yes.
So the reason you asked a question as to what was the point of showing you the scheme, when I'm not making a submission that the scheme can be construed to can be used to construe the words. If you look at paragraphs 37 and 38, this is where the judge considers the scheme and essentially comes to the conclusion that the words of the scheme ought to be read in the context. And what it meant was that that too is restricted to those who pose a terrorism-related threat.
I mean, I think this is not in any sense critical of the judge who was producing a substantial judgment in short timescale. I don't think at any point Section 22.3 is it set out? It's referred to, and some words are referred to, but
paragraph 27, where the judge sets out section 22, including section 22.3.
27.
Yes, paragraph 27.
I beg his pardon.
Yeah.
Sorry. Thank you.
So paragraph 37, 38, the judge refers to the scheme and then concludes about the scheme at paragraph 15, that is restricted to terrorism-related threats. Public interest, the reference to public interest in the scheme, the judge concludes, read in the context, relates to threat from terrorism that is real and ongoing. That too is wrong. In my submission, it is absolutely plain from the language of the scheme that it is not limited to terrorism-related threats. Paragraph 15 in my submission is equally wrong, where the judge says that the Act was very specifically targeted at dealing.
Sorry, which paragraph?
Paragraph 41 now. And Lord, you have seen paragraph 40, where the judge dealt with the scheme.
Yeah.
And effectively concluded that the words public interest in the scheme mean a threat from terrorism.
I mean, I've got the advantage of Hallsbury's. I don't have the advantage of Part 3 on data because that's been repealed, so it's not there. But the impression I've got, having gone through all the parts, all the different parts of the Act, is with the possible exception of Part 4, with which we are dealing with, every other part of the Act was dealing with terrorism. We've seen the passports, the exclusion orders.
Yes.
I know that there are bits there dealing with how you stop people getting drawn into terrorism and how you stop vulnerable people being drawn in. And everything does look to be terrorism related, with the possible exception of Part 4.
Yes. So, as I said, it can be said that one object, or the primary object of the Act, was prevention of terrorism-related threat.
Most of it is about terrorism, but you say that doesn't mean all of it.
I don't dispute that,
Yeah.
Lord. The judge said the whole object.
Yeah, and it's enough for you to say Part 4 was separate.
Precisely. But
There's a parallel, in fact, in the Rwanda case, where one of the less quoted bits of it, which did go to the Supreme Court, was the effect of some legislation, the clear focus of which was that it was essentially about immigration. But in one respect, it also dealt with an asylum issue.
yes.
And the argument for the appellants was, the whole thing is clearly meant to be only about immigration, it's not meant to be about asylum. But on the words of the particular provision, they were wide enough to cover asylum, and both the Divisional Court, the Court of Appeal and the Supreme Court all said, just look at what it actually says. The fact that most of it's about something different doesn't help.
Yeah. Yes. So
Sorry,
this,
I've been so...
no. Okay. So in this case, the point that the judge made about the whole object wasn't simply about the Act. The judge is saying that about the scheme as well. That the object of the scheme too was to address terrorism-related threat. That surely cannot be right when the scheme makes that categorically clear. It says terrorism-related threats or other interests.
It might be summarised by saying that I'm summarising your submission, not expressing an opinion, but it might be said that this substitutes the origin of the scheme for the object of the scheme. I mean, the origin of the scheme was clearly a response to a terror environment. But that's not what the scheme has become, if you're right. It's developed into a wider weapon of immigration control. Origin is not the same as purpose or object.
Yes. And again, the point with respect to law, it isn't about one object, one purpose, or the primary purpose. The judge looked at Section 22 with its conclusion in mind that, well, the whole object was prevention of terrorism. You then have paragraph 41 of the judge's decision, where the judge makes the point that the powers under the 2015 Act are broad. And makes the point that both parliamentarians and the public alike would have been reassured by the passages referred above that the powers would only arose in relation to the real ongoing threat from terrorism. Again, that with respect is simply not justified on the language that is used in the statute and in the scheme. And for that reason, the conclusion at 43 is wrong in law. The conclusion at 43 is that that the scheme only extends to those who pose terrorism-related threat. And that is the conclusion that I say is wrong in law.
And does he give a definition of terrorism related, or is it just we assume it's ordinary words and we know terrorism when we see it?
No, there is no further elaboration of what terrorism-related threat actually entails.
And does the 2015 Act contain such a definition?
Well, if not in 2015 Act, then surely there's got to be some provision in some act explaining what terrorism is.
Well, there was in a case called Palestine Action of the definition there of terrorism.
Yes, I'm just wondering where is the definition to be found in legislation?
Lord, that too I will add to the list of questions, and I'll give you a reference.
Oh, here we are. I've got it. Section. That's why Hornsby is such a good invention. It's section 41 under the heading Interpretation. Terrorism has the same meaning as in the Terrorism Act 2000, which is the Palestine Action case, and that is serious damage to property where you're intending to influence the actions of the government or intimidate a section of the public or something.
Very good.
Okay, so it's there to be found.
It's there to be found if you want it, yeah.
So in fairness to the judge, one might assume that he was he had the statutory definition in mind.
Yes. Well, this is where the relevant part of the judge's judgment comes to an end. What the judge said from paragraph 44 onwards is not the subject of the appeal.
Well, again, in fairness to the judge, he was construing the legislation in the context of what might be said to have been abuse of the power that it contained in the case that was before him.
Yes, but of course there were two separate grounds before the judge. Many separate grounds, but two separate arguments. The first is the argument that is subject to this appeal. The other argument was that on the facts of that case, the decision was irrational. If the judge had found that the decision on the facts is irrational, there would have been no appeal. The appeal is because of what the judge said in the judgment at paragraph 43. There is no authority, as the court knows, on construction of section 22, save as to the judgment in tacit. Of course, the court will hear more about tacit tomorrow, but may I show you one paragraph in that judgment that will not be the subject of the argument tomorrow, and that is relevant to this ground. So if you go to page 615 of the bundle, tab 51, you'll see the judgment in tacit. You'll see the basic background facts at paragraph 1. Mr. Tassib had indefinite leave to remain. He left the country. The Secretary of State because of a criminal conviction, made a stage 1 deportation order. Made a stage 1 deportation decision while Mr. Tassib was in Pakistan. That decision was sent to his home address here in the UK. His father provides that decision to Mr. Tassib. Mr. Tassib seeks to return to the UK at the first available opportunity. The Secretary of State refused authority for the airline to carry him, and there is a challenge against that decision. One argument that Mr. Tassib pursued was about legality of paragraph 14F of the scheme. He argued that that paragraph was ultra vires, it fell outside the bar given to the Secretary of State under section 22(3). And that argument is dealt with under ground 1. This is page 631. And the conclusion reached by the court is at paragraph 109. The judge concludes that paragraph 14F is not ultra vires.
Which paragraph?
Paragraph 109.
Oh, no.
109, page 68. 14F in that case was deployed to prevent the claimant, a person with a criminal conviction, from travelling to the UK pending more permanent measure, namely a deportation order or an
So there was no
order.
deportation order in that case at the time that he left.
There was no deportation order
At the time that he left.
at the time.
There's no decision at the time that
No
he
decision.
left.
Yes. But no
So at the
decision.
time that he left, he had indefinite leave to remain.
So he fall within the second proviso in paragraph 14F that the Secretary of State had not made a deportation decision, was in process of making one.
And his leave at the stage that the ATC order was made was a stage when he still had indefinite leave to remain, because there was no deportation order cancelling it, and when they finally did it, it was months later for reasons that for once wasn't the Home Office's fault.
So the conclusion is that 14F is within the powers under section 22(3), and that is in my submission endorsement of the submission that I'm seeking to put forward, that 22(3) is not limited to terrorism related.
The problem is that nobody thought of it. They weren't as clever as Mr. Gill. They hadn't thought of it in this case.
Yeah.
And when it was raised, when the judge saw Mr. Justice Constable's decision, what they decided to do was have a further hearing where the claim might be amended and she could decide what to do with it. But then there was permission in this case, so I think that's rather been stayed now. And in any event, she's not binding on this because she's the High Court at the moment.
Absolutely. I'm simply sort of highlighting the point that I made at the outset, that there is one judge saying something about the statutory objective of section 22 and saying that a person who is sort of facing a deportation action falls within the scheme, and that scheme is not ultra vires.
Right, and it's a further part of the factual situation in Tassib that Mr. Tassib didn't know that deportation was being considered.
He didn't know until he'd gone to see his stepfather, his father-in-law who was dying. He left the country, and then the letter was sent. And to be fair, the Home Office didn't realise he'd gone, and his father opened the letter and sent a photograph on WhatsApp to him from recollection.
Yes. So that's it. Now, my submission is said the statutory language is absolutely clear. There is no need for the court to look at extraneous
But
materials.
I'm sorry, before we leave Tassib, it was very helpful to have just to look at it, to set it alongside this. But you're not suggesting that it has any influence on the issue that we're considering.
No, simply,
You're just showing us everything there is.
No, simply to illustrate the point that I made at the outset, that there is some tension in all.
There's inconsistency, and this court should resolve it. It's your academic point.
That is the point.
Yes.
For that reason,
Yes, it's not that this judge thinks anything about the issue that's before us.
You will decide the case. There's no other authority on this, and I propose to take you to no other authority that would assist. Now the statutory language is clear. There's no need to look at extraneous materials, but if you, in the event that you reject that submission, just for the purposes of your note, then there is, and if you're interested to know more about the background of the scheme, why it was introduced, how it developed over many years, there is a witness statement in the supplementary bundle at page 210. We do not have permission to rely on that witness statement. Now, I need not to rely on it for the purposes of my argument, but I just felt it appropriate to flag it in the event you wish to look at it to understand the context of.
All right, so we treat it in that spirit.
Yeah.
Yes.
But it wasn't before Mr. Justice Constable, and it could have been before Mr. Justice Constable, and indeed it was done within 3 days of his judgment when you realised he'd lost. She'd lost.
Yes, but that judgment, Lord, Lord Justice Lewis has, of course, read it. It simply sets out the sort of chronological background of the legislation. The author of the witness statement was involved in the legislation and how it was involved.
Well, I was speaking of myself as not being steeped in this. The factual information is of interest to me. I'm less interested in any expressions of opinion about what it all means, and you're not seeking to interest us in that either.
No. Among other things, that witness statement also includes a statement that was made by the minister
Yes.
in Parliament when the scheme was put before Parliament.
But that can't be admissible, can it?
No.
So, unless the pepper and heart test is met, I'm not.
Well, no, it can't be admissible even on pepper and heart, because at the time
Yes.
that will be admissible as to what the minister intended the scheme to be. But that wouldn't help you unless it was intra vires the statute.
Yeah.
And this was several years after the statute.
Yeah. So and of course, in advancing my ground, I'm sort of criticizing the judge for relying on extraneous materials, notes, etc. So I do not place any reliance on them.
All right, but in any case, as part of our decision when it comes, we'll have to say something formally as to whether your application is granted or not to rely on the witness statement. But we have it now in scope. Right. Yes.
There was an application which my Lord Justice Lewis said would be decided
I know
by
it's listed.
this court.
It's listed for us to deal with, so we'll have to deal with it.
May I just make it absolutely clear that I'm not seeking to rely on the witness statement to impugn what the judge has said. It's simply for the background purpose. But other than that, I place no reliance on it. Unless I can assist you any further.
Yes, you can just help us in what you're asking us to do.
Well, of course, that's entirely clear question. I'm asking you, of course, to conclude that the judge got the law wrong, and
The remedy. I'm looking at the order down below, and you can't undo the quashing orders. You haven't got permission. So, are you trying to undo paragraph 3.1 of the order, or are you granting
Can we look at the
declarations, page 78 of the core bundle? Or are you trying to get a declaration simply that it's not limited to terrorism-related activity, or that it does include 14F?
Can we just review the orders? Right. So we will have at 70
yes. So page 77 is the order
of the core bundle. Well, wait till we've all got that in front of us, and then you
there's
can
another one.
tell us what you would like to suggest we should do about it.
yes. So paragraph 78 of the bundle.
Page 78.
Page 78 of the bundle. Yes. So this is page 2 of the order, and paragraph 3 of the order identifies the grounds that the judge determined. And ground 1 is the ground that is subject to this appeal.
Right, so it's a determination.
Yes.
And you want us to set aside that paragraph 3.1, do you? Because that says the scheme was inapplicable to the claimant, and that's because he wasn't a terrorism-related person.
Yes.
So set aside the determination referred to in paragraph 3.1 of
Yes.
the order,
That-
as reasoned in the judgment.
Yes. Everything else stands.
And you're not asking for anything else, the declaration or anything else, it's just setting aside 3.1. Is that it? Or I haven't seen any draft declaration.
No, I'm not. So a judgment by this court with quashing of that aspect of the determination will give the Secretary of State what she
wants.
Well, we're not. I mean, we're not. Are we quashing that determination? Is that strictly correct?
No, we're setting it aside.
You set aside that part of the order.
But the quashing order stay in place, and
sorry, the
everything else stays. Yeah.
Yes, exactly. So it risks confusing what we're doing. So
My apologies. Set aside. Yes.
right, and setting it aside to the extent only that you introduced at the beginning of your submissions,
Yes.
which is to say that it was wrong to say that this was out with the power under the Act.
Yeah. Yes.
That 14F, which was the
Yes.
power under which the ATC was issued, was out with Section 22, or out with the power in Section 22, was 23. But whether or not we're in a declaration, you want our reasoning to make clear that para 14F of the 2023 scheme is intra vires. Is that right?
Yes, and applies to FD.
Well, yes, I think.
But that doesn't really matter, does it?
No, it matters for this reason, my lord, that if you look at the judge's reasoning that I've taken you to, so he comes to a conclusion about Section 22.3, but he also then comes to a conclusion about the scheme itself. And he says, and you'll hear more on it from learned friends, he effectively says that the scheme, forget about the statute, the scheme is also limited to terrorist-related things.
Yeah. Well, do you think that's because he reads it in the light of the legislation?
Yes.
And that would go. The other thing is, although you say 14F, there is a huge distinction because
between two parts.
yes,
In the two
because
parts.
you only got a deportation order in your case,
Yeah.
and that might be fine. Goodness only knows. But the people who are subject to it and whose indefinite leave to remain has not been cancelled might be different. So I'm not sure that in this case we can go beyond the first part of 14F, if you follow me. The bit about deportation orders.
I have no difficulty with
Happy with
that.
that?
So we keep away from the issue that arises in the other appeal
Yes.
for the purpose of this case, right? All right, that's
Could I just ask one question? Are you aware of any authority of this court or above addressing the effect of the phrase necessary in the public interest? Not just in the public interest, which obviously you will get in dozens of pieces of legislation, but that particular formulation, necessary in the public interest. Are you aware of any case where that phrase has been considered?
No. Unless I can assist you any further.
no. Thank you very much to you both. Yes, Mr. Gill.
My lords, so far as the question of whether the court decides to hear, not just hear, but to rule upon the question that the appellant has raised, there's not an awful lot that I really want to say to what is already in writing, because I've heard what the court has said. Clearly there are a large number of cases which could be affected. Our concern, however, is, and this is entirely a matter for the court, that the issue does in fact become, in effect, a judgment divorced of the facts. And I appreciate that your lordship said that there can be some circumstances in which a court rules on what looks like an academic matter, but nevertheless, because it is before it does have it does become binding.
But take an example. I mean, in an area with which I'm more familiar, the leading decision about the withdrawal of medical treatment from incapacitated adults was decided. The Aintree and James decision was decided 6 months after the unfortunate Mr. James died.
My Lord, I'm not suggesting that there aren't situations like that.
No, of course there are situations, but I mean, if your submissions in relation to jurisdiction scope of the power are right, then it's very much in the interests of people in the position of your client who was on the wrong end of a, as it seems to me, abusive decision, to have this made clear.
My Lord, I don't disagree.
So it's difficult to see how otherwise the matter is going to reach this court, other than in an absolute situation of emergency where it can't be very easily argued. That was my principal concern about passing on the opportunity to look at this matter of construction. And actually, we do know what the facts are. I mean, the facts are, in this case, strong in your favour.
Yes, yes. Well, my Lord, I don't want to be labouring any points.
Well, I mean, if you were to read later on that you very properly raised this as a question for us to consider, but didn't press it further than you had done in your written case, would that be a fair reflection?
My Lord, certainly. It's entirely a matter for the court. We've just come along to try to assist the court insofar as we can, frankly. Lord Magister. There is the question, and we, I think, touched on it in the written argument, as to whether anybody can, in fact, then appeal if you were to make a judgment on what is for FD an academic matter. That does pose that particular problem, because it means the decision ends and is decided here, and the chances of the matter going up to the Supreme Court.
Why would you be, as a matter of principle, disabled from appealing if you considered that our conclusion, if it was against you, was wrong?
Well, because the Supreme Court may say, well, it actually is truly academic, and whilst we would have jurisdiction, we do not intend to exercise the discretion to hear it. There would be that problem. The other problem is not so much a jurisdictional one, but a practical one, in that, in reality, legal aid agency being what they are,
yes.
Right.
So you'd in leaving it to us, you'd invite us to consider the possibility that we might make a wrong but practically unappealable decision.
Exactly.
Yes.
Exactly. Well, Lord, that being said, so far as the first ground, in fact, it seems the only ground 1A, that is being argued today. We say this firstly. This argument was presented to the judge on the assumed basis that 14F could apply to a person such as, or did apply to a person such as FD. It was never accepted that there was an extant deportation order, or that the Secretary of State was in the process of making a deportation order. In fact, it was argued that whilst there was previously a deportation order on the 12th of May 2017, the deportation order had fallen away by the time the grant of ILR, at the time that the grant of ILR came, because the grant of ILR was completely inconsistent with the terms of Section 5.1. None of that matters for present purposes, because the whole argument under this part of our FD's ground 1 for judicial review, and it's the first part of FD's ground 1 for judicial review, and not the second part. It's only the first part. That first part was being argued on the assumed basis that 14F would apply, applied, and the Secretary of State believed there was a deportation order. We didn't accept it.
But there was a deportation order, as I understand it now, having been reminded of the fact. There was a deportation order that had not been revoked. So when you say fallen away, what happened was two inconsistent things were happening. A deportation order was happening, and he was being given an electronic visa, and both of those shouldn't have happened at the same time.
I don't think it's going to matter for present purposes, my lord, but that is not the correct analysis. The fact is that the Secretary of State treats applications for asylum and protections as applications to revoke a deportation order.
Applications to revoke.
Exactly.
And they either hadn't taken a decision because they hadn't sent it, or if they had taken a decision, it was actually, as I understand it, adverse to your client.
I don't want to take time over this, but because it is not actually an issue before the court at all. But essentially, the position then is that the application was made, it's being dealt with, FD, and it's the chronology attached to our JR skeleton argument in the High Court, which I'll take you to in a moment. I'm just trying to summarise this to get this out of the way. FD was pressing, saying what's happening to all this application. They said, well, make an NTL application. He did. They gave him ILR. So the grant of ILR, at the very least in his mind, was the resolution of that asylum claim and the application to revoke the deportation order, and two statements. One, in the deportation order, leave the country and don't come back, 5-1, completely contradicted by the other statement on the 9th of December.
How is it just, I'm anxious to just understand what point you are making about this, because it's to do with the fact that the matter was argued on a different basis before the judge to the basis which is being presented to us. Is that the point you're making?
The only point I'm making is that this argument on the construction of the Act, Section 22(3), and on the scheme and the construction scheme, was argued on the assumed basis that he was the subject of a deportation order. Whether he was or not is a different matter, not relevant for present purposes. It still does, you can still rule on the question.
Right.
Yeah. Yeah, you're just saying you want to make it clear that it's an assumed basis, not a basis that you ever accepted below.
That's right.
Yes.
And the judge was with us on this, but none of that is up for debate here. And the issue one is purely one of construction here, which is because the Secretary of State is concerned as to how this might apply in other cases. It may be used in other cases. So far as that is concerned, it involves the construction of two things. One, Section 22, 22(3) in particular, and the ATC scheme. As regards the ATC scheme, we haven't actually been able to find the regulation to which the ATC scheme was appended. The closest that there was the regulation which is in the bundle, which was the penalties regulation. But I've not been able to find it. And so Lord Justice Lewis's point that perhaps it's all unlawful.
Well, I'm looking at, I'm making the assumption that what appears on the National Archive as legislation is legislation, but I'm just looking at the Authority to Carry Scheme and Civil Penalties Regulations, which is the same text, 2023.
Yes.
And that exists as 2023 number 326.
Yes. But that, I think, is the one that was shown to your lordship. It's not.
No,
no.
The one that was shown to us.
I think it's the one which was missing from
Yes,
the bundle.
So.
But basically, Regulation 2. Regulation 1 says what the regulations are, and Regulation 2 says the ATC Scheme 2023, which was laid before Parliament on 9th January 2023, comes into force on the day which these regulations come into force. So that looks like an enabling provision.
then we've got the wrong one, I think.
I think we've got the wrong one in the bundle. And I think you'll have an opportunity, obviously, before we give a decision to run this to ground and reach an agreement about it. But it looks as if there are enabling regulations.
It looks like it, yes.
Yeah.
Well, if it assists, I do have those regulations now. I'll share those regulations with Milan and
All right.
and we'll provide you.
Well, we'll wait for a confirmation that you're both agreed that those are the relevant regulations.
So far as the construction of Section 22 itself is concerned, our position is that the judge was right in his construction of Section 22 and indeed in his construction of the ATC scheme. And we respectfully submit that both things have to be looked at together. It's not that it's just the statute itself. So far as the
Sorry to take you up on that, Mr. Gill. Can that be right? I agree they've both got to be looked at, but looking at them together risks blurring two distinct questions. The first question is, what did the statute mean, at which point the scheme didn't even exist? And Mr. Malik has disavowed any reliance on the terms of the predecessor scheme. So surely we should look just at the statute, and then, having looked at the statute, look at the scheme.
My Lord, I'm content with that way of putting it.
Sorry,
and it may be that my reference to it together was not.
No, perhaps I was picking you up unnecessarily. Sorry.
So far as the statute is concerned, we say, even looking at that as it stands, without looking at what was preceding, etc., which is Mr. Watkins's statement, it is clear what the purpose of Section 22.3 is. The statute is set out at page 141 of the authorities bundle. And the table of contents, which is the Westlaw version at page 149, is there to give one an overall idea of how the Act is laid out as a whole. And as was pointed out from the bench, with the possible exception of Part 4, it all seems to be terrorism related. And we say Part 4, for present purposes, is not an exception. It is part of the general scheme to take counter-terrorism measures. This is, and for this purpose, one looks at the Act as a whole when we construe Section 22.3. So one sees what the structure of the Act is from that index. The Act is too huge to put in, but that's why the index is there. So far as the preamble is concerned, on page 141, it says, an Act to make provision in relation to terrorism.
Well, it says other things though as well.
It says other things, yes.
That's the problem, isn't it?
To make provision about retention of communications data, about information, authority to carry and security in relation to air, sea and rail transport, and about reviews by SIAC against refusals.
It helps to look at the semicolons.
Yes.
It's really about two things, and then the third one, and for connected purposes, which is obviously just ancillary. So the two things are, one, terrorism, and two, provision about, then a variety of what I might call sub-things. But quite clearly, the Act is actually distinguishing between provision in relation to terrorism, up to the first semicolon, provision in relation to various other matters, up to the second semicolon.
Well, my Lord, I can
Isn't that
see.
right?
I can see that that's one way of reading it. I don't think that's right, because one has, nevertheless, those three parts of the separated by the semicolons do have a linkage between each other. Of course, if that's all that there was, then that wouldn't be enough. I understand that, but it is indicative, especially one sees the structure of the Act itself, the index, which is at page 149. So then one gets...
Could you just help with, before we leave the preamble, where in the second line it says authority to carry and security, what bit of the legislation might and security particularly refer to?
That is all, both those two things, authority to carry and security, are linked together, we say. They're not two separate things.
Well, I'm sorry, but if you look at the Act, 23 and 24 deals with the schemes. 25, and I haven't read it in detail, is headed Aviation, Maritime and Rail Security. And then there are amendments to do with aviation and maritime security.
So security is conceptually a different issue
It's
than
in a
an
separate
authority to
subsection,
carry.
but I haven't gone through Schedule 5. And it just makes, it makes lots of amendments to different bits of different acts.
Yes.
But it does look, if you look at, if we've got 25 in the bundle, because I'm looking at all these, but 25 has actually got a separate heading.
My lord, I see that, but
So it's another part of Part 4.
Yes. It's in the bundle.
these are further amendments to do with aviation, maritime and rail security. But
Right, so I was only interested in whether authority to carry and security was, as it were, a single term of art. In fact, it's referring to two different things.
my lord, this Part 4, however, is, the purpose of it is, as we see from the preamble and from the structure of Part 4 itself, to do with aviation, maritime and rail security. Now, I understand that your lordship is drawing a distinction between the heading to paragraph 22, for instance, and the heading to paragraph 25, and I see the force of that point, but nevertheless it's all part of one part, all part of an act concerned with terrorism. That on its own is still not necessarily enough to limit those words public interest to simply...
No, I'm looking for the least matters that might give the least assistance to the construction process. I quite understand it's not in any way decisive, and I've now found section 25.
Yeah. So what one then has to look at is, well, when section 22(3) uses those words, necessary in the public interest, how are those words to be interpreted? What is necessity? Necessity for what purpose? Necessity, presumably, for something to do with a public interest. But what is the relevant public interest? The relevant public interest must depend upon the context in which section 22 sits, and that context is the Act. It is not some open-ended public interest. Otherwise, this provision could have been introduced in some other amendment to an Immigration Act, for instance, in just one section or something. This is being introduced in the context of an act which is to do with counter-terrorism measures. Context, as Lord Steen said in Daly, is everything. And so it is in the construction of statutes. Sometimes there might be situations, and your lordship, I think, was postulating some situations where one can look at the words of a particular section on their own, divorced from what is surrounding it. But that is difficult to do that in relation to this Act, because those words in the public interest are unclear. What does one mean? What type of public interest that might be? This maybe a bit absurd, but you know, the next thing I'm about to say, but public interest can be all sorts of different things in all sorts of different fields of law, whether they've been housing or planning or whatever. It can mean anything.
Well, take it. I mean, you're not descending to an example, but may I just offer this? Let's suppose there was no particular legislation in relation to communicable disease, and there appeared in the scheme a refusal, a power to refuse authority to travel to people who had a certain communicable disease. Now that would obviously be nothing to do with terrorism, nothing even to do with immigration.
Yes.
What would your submission be about that?
If it was on its own.
If it was subparagraph Z to paragraph 14, a class of persons was included people who had a communicable disease, which was then specified.
Oh, my submission in relation to that is that, and I think it goes for everything that is in paragraph 14, my submission is that paragraph 14 is simply a list of potential or persons who are potentially subject to the scheme, but in order to be subject to the scheme, they also have to be a threat to the UK.
Well, you're blurring two separate things, aren't you? There's the power to specify the classes in the first place, and it's the specification of the classes that has to be in the public interest. Then there's a separate question, having specified the classes, under the scheme as drawn anyway, it's discretionary. It could possibly be mandatory, but it's discretionary.
Yes.
Under the scheme as drawn, you then have a discretion. There's the statute doesn't tell you by reference to what criteria you exercise the discretion. But realistically, you might say, well, this class of persons, it was reasonable, necessarily in the public interest to specify, but now we have to make some distinctions between people falling within that class, they don't pose a real threat or whatever.
Yes.
That's really what you're saying.
Yes.
But at the moment we're still on the primary question of what the statute allows. And my Lord's question is, would it be with intra vires to specify a class of people with communicable diseases?
The short answer to that is yes, it would, but that on its own is not enough for that class to be identified.
Well, sorry.
The reason for that...
if I may say so, it's a self-contradictory answer, isn't it? I was asking whether it was intra vires for that class of persons to be specified. I must say, I thought you were going to say no.
Well,
because it's not communicable disease, not nothing to do with terrorism.
Well, my Lord, my point is that on its own, no, which was the latter part of what I said, that on its in itself, yes, but not on its own. It has to be linked to terrorism.
I see. So people with communicable diseases who are linked to terrorism, yes.
Yes.
But then you don't need communicable diseases because I mean your thesis is that there shouldn't be a list at all. In effect, the list is a list of one qualification, which is that they're linked to terrorism, and at that point we then have to grapple with what does that mean.
Your argument should really be if Parliament wants to stop people with communicable diseases or people who are sanction busting or serious criminals coming into this country, they should do so. But your real submission is it's not right to interpret an elastic phrase outside its context. That's what you're really saying, I think.
Well, my Lord, I'm grateful.
Sorry.
Indeed, I mean, all I'm saying is if I try to pull it back to the statute itself, those words in the public interest require definition.
And if Parliament wants to do other things about other things that are dangerous or difficult, then they must do so. But you shouldn't say, well, that's a good idea, we'll stop that, and we've got this act, and we'll take those words out of context. That's your essential submission.
That's essentially what I'm saying. It's just the Secretary of State has chosen to do it in a somewhat odd way. They've chosen to then exercise this discretionary power. It says may specify or describe. They've chosen to exercise that discretionary power in such a way which starts off in the ATC scheme by talking about what we say is the purpose of Section 22.3, which is stopping terrorism-related activity or activity which is a threat to the interests of the UK. And then saying the types of situations in which we will exercise that power, the categories of persons in relation to whom we will exercise the power, are this list in paragraph 14F. That list in paragraph 14, that list in paragraph 14 is a strange way of doing it. It seems that that somebody has thought that maybe they can do everything connected with immigration through a list through a list in paragraph 14, but they haven't thought about the fact that Section 22.3 doesn't in fact permit them to do that.
Right, well, we'll take that thought away with us, if we may, and come back at 2 o'clock. Thank you.
Rise, please.